versus Taylor. As you know, Justice Simonis has retired. Justice Lee will soon retire. As a result, we are joined by Judge Hagan and Judge Harris from our Court of Appeals. And we are very fortunate to have them join us and appreciate their service. A few preliminaries. If we have a technical glitch, don't worry about it. We'll take whatever time is necessary to ensure that you have a full opportunity to present your case. If you have a question, we'll raise our hand. That's to signal, first of all, to each other, and also, of course, to you, that we'd like to be next in line. Excuse me. Doesn't mean you need to stop mid-sentence, mid-thought. But when you reasonably can, please get to our question. It is our practice to continue to ask questions as long as we think it will be helpful to our understanding of your case. That may mean that at the end of the argument, one of you has had more time than the other. It's simply a function of how many questions we had of the respective sides. Probably helps in terms of bandwidth if you mute yourself when you're not speaking. Okay, I think I've checked all the boxes on the preliminaries, so we are ready for counsel's appearances.
Good morning, Julie Nelson for Appellant David Taylor.
Good to have you with us, Ms. Nelson.
And Bo Olson on behalf of Jill Taylor, the appellee.
Mr. Olson, good to have you with us as well. We appreciate you both appearing virtually today. Okay, let's jump into things.
May it please the court. This case presents an interesting question about the intersection between two robust, well-defined areas of the law. On the one hand, we have divorce law, and we know from literally decades of case law that the court must retain the authority to review any agreement that the parties make, because it is up to the judge to make sure that equity has been done. The case law is legion that is the role of divorce law. On the other hand, we have arbitration, which has a very valuable place in the Utah legal system, but it is binding. And there is no place for the judge to review what the arbitrator has done and decide if it is equitable. Because of those two well-defined areas of the law, the question today is, can they overlap? And the answer is, they can't right now, but they could. The legislature could easily say that an arbitration in a divorce case is a recommendation and should be treated the way that any other recommendation to the divorce court is, whether it's a stipulation from a mediation, a custody evaluation, any sort of expert report.
Can I ask you a little bit about the way you've framed this case and bringing a challenge under 107 of the Arbitration Act?
Yes.
Is that not something that your client waived by participating in the arbitration and then submitting the award to the arbitrator? It seems like once your client made the decision to participate in arbitration, we should be talking about the grounds to vacate, and perhaps even the public policy ground to vacate that we suggested might exist in Bouzas versus Salt Lake Bees. So help me understand why we shouldn't be talking about grounds to vacate rather than the enforceability of the agreement under 107, that your client just waived that by participating in the arbitration.
Okay. Well, to be clear, we have also argued about grounds to vacate, right, on the basis of imputation. And we can also talk about that. That is part of our argument. But I think that when a party enters a contract, any kind of contract, there's always a question as to whether it can or should be vacated at law or in equity. We saw that in Kiernan just last summer, where a party had entered into a contract to waive a statute of limitations. And this court said, you can't do that. That's void as against public policy. And in Kiernan, they cited to an older case called Hertler versus Hertler that I can't tell if it's a divorce case, but it might be, right? And it says statute of limitations are not designed exclusively for the benefit of individuals, but are also for the public good. And that's why you can't waive it. And I think we see the exact same setup here, where we have that the arbitration agreement is a contract, but it's not designed exclusively for the benefit of individuals. It's also for the public good. Divorce is also for the public good. And so an arbitration agreement, like any contract, can be challenged or set aside. We see that with some regularity. Somebody enters a contract and then they come in and say, you know what, actually the contract is void under law or in equity. And that's where it intersects with section 107. So that's why we framed it that way.
Can you tell me what ground under 124 you challenged? I mean, I know you make the manifest disregard with respect to some aspects of it, but what's your argument that under 124 the entire agreement should be vacated because it's contrary to public policy?
Well, so the entire agreement is contrary to public policy in the sense that arbitration in the divorce setting is contrary to public policy.
And which ground under 124 does that fall under?
Well, I mean, that's why we framed it under 107, really, because we're saying that the agreement needs to be set aside entirely. As to the vacator, we have focused on manifest disregard on imputation. And we don't have case law saying that you can just vacate a part of an arbitration agreement that I'm aware of. I think that if part of it is wrong, the entire thing needs to be vacated. But we've also asked that if it's acceptable to only vacate a part of it, then this court do that under manifest disregard.
So I take it that you couldn't find a ground under 124 that speaks to public policy?
Well, we have exceeded their authority, right? And if they've exceeded their authority by erasing the trial court's ability to give a final stamp of approval or to keep a watchful eye, then they have exceeded their authority. And that's fundamentally the problem here, is that an arbitration, because it's binding, eliminates the trial court's ability to approve it in any sense other than just confirming it under 123. And to be clear, confirmation under 123 requires a motion. Well, confirmation, vacator, or modification and correction requires a motion of the parties. The judge can't do it sua sponte, right? The utility trailer case that was quoted in Amigo specifically reminds us that awards will not be disturbed because the court doesn't agree with the award. But divorce law requires that the judge retain that ability to disturb the award because the court doesn't agree. Judge Hagan, did you have a question?
I just had a follow-up about 107, because you're relying on the language upon a ground that exists at law or in equity for the revocation of a contract. And I'm just wondering, is what you're asserting a ground for revocation of a contract? I mean, when I think of that term, I think of things like fraud or mutual mistake or something along those lines. So is saying that this subject matter is simply not subject to arbitration, is that a ground for revocation of the contract?
Yes. And let's remember that 107 says at law or in equity. And so equity is what controls all of divorce law, and also at law, because everything in divorce law, including just about every provision of section 30-3-5, says that the court must be able to do this. The court must be able to do this. The court, because that's how divorce law is set up. So if you then have an arbitration that is binding, then it conflicts with that area of divorce law, and divorce law is more specific. Therefore, it doesn't work. But it's not just, the scenarios that you listed, like fraud, that is one of the scenarios. But like I said in Kiernan, that wasn't a fraud situation. They simply said that you cannot contract around a statute of limitations because of the public good. That's why you can't do it. And that's where we are here. You can't contract around the court's ability to review something. Simply in the divorce context, we have a lot of cases that tell us that you cannot contract around the court's ability. We have In Re EH, which is a case from this court, where the parties contracted that they would have a custody evaluator decide custody. And this court said, you can't do that. You can't take that away from the judge. The judge has to be able to decide who gets custody. Justice Pearson.
So in Re EH, did we invalidate the agreement to send it to a custody evaluator, or did we just try to harmonize that with the divorce code and say, well, it's okay as long as the court retains some ability to review it?
Right. It was treated as a recommendation. And if an arbitration award were treated as a recommendation, then I wouldn't be here. I think that actually that's the appropriate way for an arbitration award to be handled in divorce law. And whether the legislature does it, or I suppose this court could do it and say, all right, arbitration awards are recommendations, just like anything else going to a divorce court, that would be okay. I'm not saying that I'm not anti-arbitration, and I'm not even anti-arbitration in the divorce context, as long as the trial judge retains the ability to approve it. Justice Peterson.
Following up on Judge Hagan's question, I had a similar thought about revocation. It seems like what you're arguing is that the binding arbitration award is void as against public policy because it conflicts with settled family law.
Yes.
Is that the same as revocation, or is 107 talking about something different?
I mean, I think it's the same as revocation. What are you suggesting, that it's talking about something different?
I don't know. They're two different words, and I'm just wondering if I'm just trying to fit this idea that this is just void and you cannot do it with the language of 107. And so if you could just speak a little bit to how that fits as a ground under 107.
Sure.
I think that's what I'm getting at. And I don't have the answer to my own question. I don't know.
I think we have to recognize that sometimes arbitrations need to be set aside. There are some things that are simply inappropriate for arbitration, even if the parties enter into it. And I think about other contracts. Let's take an extreme example. A contract for a hitman is void and unenforceable. It just is. It doesn't matter if you signed a contract for it. So here we enter into a contract to make an arbitration award binding in the divorce context. You can't do it. You've circumvented the divorce court's authority, and therefore I don't see how we can frame it other than to say that the contract needs to be set aside as void.
I suppose, and I think Justice Peterson and I are getting to the same point here. Saying that a contract is void, basically ab initio, because it's against public policy, is that the same as saying that a contract can be revoked? I mean, is saying a contract is just simply void. Does that jive with the statutory language allowing for revocation of a contract?
You mean void versus voidable?
Yeah, exactly.
Well, it could be voidable, except that in theory, something could be voidable. I understand that. I just don't see here how this particular one could be voidable, because the fundamental point is that it's binding and it can't be. And therefore, it needs to be voided. Now, I suppose there are other things like, I think it's section 116. I can't remember. One of the arbitration provisions allows you to contract away parts of the Arbitration Act, right? So we could instruct parties that they can arbitrate as long as they agree in their arbitration agreement that it's not binding. That would work, and then it would not have to be void. But where you've just entered into the Arbitration Act, taken it wholesale, then 107 provides this ground that exists at law or in equity. I mean, if we say, well, once you've entered an arbitration agreement, then there's no way out of it, then 107 has no meaning. But if 107 is going to have any meaning, then we have to recognize that arbitration awards can be set aside on a ground that exists at law or in equity.
So I suppose that the only thing I'm trying to reconcile is the argument with the language of the statute. So the statute doesn't say they can challenge the enforceability of the arbitration agreement if it's void, or if it's illegal, or if whatever. It just says upon a ground that exists for the revocation of a contract. And I'm just trying to square the argument that it's simply void with the language of 1071. And you just don't see any distinction between grounds in law or equity for revocation of a contract and your argument that it's simply void.
Well, I mean, my argument is that it needs to be revoked. The whole arbitration act, the arbitration agreement needs to be revoked. And once it's revoked, then that's the same as saying that it's void. I mean, maybe there are two different steps along the timeline, but it needs to be revoked for a ground that exists at law or in equity, and therefore it will become void when that happens. Judge Harris?
Yeah, I mean, I understand your argument that we've got a bunch of case law indicating that stipulations aren't final in the divorce context and that stipulations are subject to some sort of judicial review to make sure they're equitable. But I'm still not tracking your argument that there's a statutory basis in 30-3-5 or 30-3-10 or really anywhere else that implies that arbitration is something bad. It seems like the references to the court in those statutory provisions just say things like, when a decree of divorce is rendered, the court shall include the following in the decree. And if the court's deciding this, here are the factors the court should be looking at. It doesn't seem to me. I'm looking at these statutes, and I guess I want your help to point out exactly where in these statutes you think there's some sort of mandate that a court has to be the decision maker on these things as opposed to somebody else.
Well, as you started your question saying that there are all of these cases that say that exact thing, right? And so if we were to say that arbitrations are binding, then we would be carving out something away from all of those cases that talk about that. I understand 30-3-5 to be the basis for those cases, saying that the court is supposed to do all of these things. I agree with you that there is not a provision that says the court and only the court may do this. But that's how I think we get all of those cases, is coming out of that language from 30-3-5.
So that's why you mentioned at the top that you think the legislature could change this to make arbitration awards be some sort of a recommendation to the court. And then you kind of shifted and said, well, maybe this court can do it as well. And I think maybe the reason you said that is because there's nothing in the statute that would sort of mandate the conclusion that you started out with, right? I mean, if it's case law driven, then this court could go there, right? But if it's statutory driven, then we couldn't. And that's why I'm trying to get at whether you think there's a statutory basis for the court having to be the final decision maker in these cases.
I think the statutory basis is in the Arbitration Act. And I would think that the amendment would need to be in the Arbitration Act, saying that it can't be binding in a divorce case. But I agree with you that the body of case law is the root of the divorce statutes. And therefore, this court could say that it's only a recommendation. That would be acceptable. The key is that whoever says it, the divorce court needs to be able to put a stamp of approval on it other than simply to confirm the arbitration award or modify, correct, or vacate under the Arbitration Act.
Maybe I was misunderstanding, but I thought your argument under the Arbitration Act was that this was revocable under public policy, and the public policy you were pointing to was the divorce statutes. Am I wrong about that?
Well, not just the divorce statutes, all the divorce case law as well. I think that's where we see the public policy fleshed out, is in the cases. But they work in harmony, right? There's no conflict between the statutes and the body of case law. And when we are litigating family law, we're around the edges, but we're not in that core center talking about things like making sure that the parties, in divorce cases, we're worried that the parties are not negotiating at arm's length. We're worried that one of them is manipulating the other one. There's a state interest in every aspect of divorce cases. Even Dahl tells us that it's in property distribution. That's why you can't get married or divorced in this state without state supervision, right? I mean, there's a statutory basis for that you cannot get married or divorced without court supervision. Otherwise, I mean, there's no point here. So that's why we have this, the court need to have this watchful eye.
I guess what I was getting at is if the underlying public policy basis that you're using to sort of be your lever for the Arbitration Act argument you're making. If the underlying public policy basis is judicial decisions, then those are things this court could sort of clarify or take another look at, as opposed to if it were a statute you were pointing to as the basis for your public policy argument, we would obviously be constrained by what the statute said. That's what I'm trying to clarify. And it sounds like what you're saying is ultimately you're relying on case law more than anything else to point to the public policy basis for your argument.
Yes, and to the extent that that case law gives this court permission to do that, then yes, I agree with that. Justice Durant.
Are there other categories of cases, perhaps cases when the state also has an interest, that have been found to be non-arbitrable?
I don't know of any in Utah. I don't know the answer to your question. I don't know if there are any others. I think it would apply to any area of the law where the court has to give the final stamp of approval. Justice Peterson.
Chief, were you finished with your,
Yes.
Did you have follow-up?
No.
It seems like when you're saying that this is revocable, kind of in the vein of being void, it seems like what you're saying is the parties simply don't have the power to do what they're trying to do here.
That's exactly right. Thank you. That's exactly right. And there are other areas of divorce law where we have said the parties do not have the power to do that. Sorry. And there are areas of contract law, right? The Kiernan case is, I mean, I keep saying it, but you do not have the ability to contract around a statute of limitations. Sorry. You do not have the ability to contract around the judge's ability to review your divorce decree. And there's a good reason for that. I mean, what if you go to mediation? What if one party is being really manipulative to the other? You go to mediation, you enter into the settlement agreement, you give it to the judge, and the judge says, I'm not going to sign this. So then you go to arbitration and you make it binding. Well, then you've circumvented the judge's ability to say, no, I'm not going to sign this.
And
that's our concern, right? Is that they're not dealing at arm's length.
I think maybe the strongest example of that would be if the parties through arbitration got a child support award that was not the guideline child support amount. And routinely the judge will say you're not allowed to do that unless you make some real showings about why you're deviating. And I don't know, judges basically say you don't have the power to do that. This is a mandatory child support statute.
That's exactly right. That's exactly right. You cannot arbitrate what the child support should be, right? You have to go by the tables. And you're exactly right. People will enter into a mediation agreement and say, I'm going to make my child support's going to be $1. And the judge says you can't do that. Sorry. But if the arbitrator approves it, then the judge doesn't have the ability to say no. Justice Durant?
Yeah, it really does sound more like a voidness argument than a voidability argument. And when we conduct a voidness analysis, we first require that the public policy at issue be identified. And it sounds to me like you would point to just the public policy and having judges make the decision to ensure that there's no bad result as a result of unequal bargaining power.
Right.
And then we require a clear statement of public policy. And from your responses to Judge Harris's question, it sounds like your argument is that public policy can be found primarily in case law, but also in the statute. Is that so far a fair characterization?
Yes.
And where in the statute, what would you point to for the statutory support for this clear public policy?
Well, Section 1, which soon will be Section 2, but Section 1 tells us that the court must enter equitable orders. And I think everything else flows from that. So 30-3-5 subsection 1 tells us the court should enter equitable orders, and it lists out things that can be entered, and everything flows from that. The rest of the statute flows from that. The rest of 30-3 flows from that. And our decades worth of case law, I think, flow from that one premise.
I mean, does that almost suggest that as to equitable matters where the judge necessarily plays well, certainly has more discretion, that they're less subject to arbitration or should not be subject to arbitration? What exactly is your argument in that respect?
Well, my position is that no areas of divorce law are exempt from the court's final watchful eye. Property distribution seems like the sort of thing that maybe would be on the closest end to something that would be acceptable under arbitration, but Dahl tells us that the state has an interest in making sure that assets are divided equitably. So if even property distribution, the state has that interest, then I think we cannot pass that off to an arbitrator. At the far end would be child custody and child support, right? Those things belong to the child. The trial judge is responsible for finding the best interests. The trial judge can ask a special master or ask a custody evaluator or a guardian ad litem to give a recommendation, but in the end, it's up to the judge. And that's where I think an arbitration award would be the same. It would be treated as a recommendation, but in the end, it's up to the judge to decide. So am I answering your question?
Well,
I think you asked about different areas of divorce law.
I think that, it could potentially have far-ranging consequences if we were to suggest that where a court sits in equity, or any matters where a court sits in equity or has a high level of discretion, that those kinds of matters are not subject to arbitration. I know you're not arguing that. I know you're restricting it to the divorce context, but
but I'm restricting it. Sorry to interrupt. Go ahead.
No, you go ahead.
Well, I'm not restricting it just to anything where the court has discretion. I'm restricting it to anything where the court is required to give the final stamp of approval, right? Divorce cases are civil in the sense that they're not criminal, but they're not civil in the ordinary sense. And in the ordinary sense, a judge just, decides where your property boundary is, something like that. But in the divorce context, we do have this unique feature that it has to be the judge who enters the final order, who looks at the final order, not just stamps the final order, but looks at it. So yes, I think this argument would extend to any areas of the law where that was necessary.
Thank you.
But only those, not just every area where there's some sort of discretion. Judge Harris.
Is it useful, do you think, to look at what other states are doing in this regard? I didn't see much in the brief other than maybe a footnote here or there sort of alluding to what other states are doing in this regard. But is it too statutory bound in other states for us to look to other states? And do you have any sense of what other states do in terms of whether divorce matters are arbitrable?
I know that in other states, divorce matters can be arbitrable, but it's because there's a statutory basis for it. Or there could be a case law basis for it, as you're saying, but we just need to clarify, and in Utah, we know that divorce cases have to be approved by the judge. If another state doesn't have that as such a strong rule, then it wouldn't matter, right? A mediated agreement is the best comparison. If a mediated agreement just gets entered and the judge in another state doesn't have the ability to change that, this wouldn't be a conversation there. So it's the intersection of having both of those schemes simultaneously. They're rubbing up against each other here and causing some friction. So other states handle it by having one or the other of those bodies of law be a little different. I will reserve my time for rebuttal.
Thank you, Ms. Nelson. I probably should have mentioned earlier on too that when time is exceeded because of our continued questioning, it doesn't count into rebuttal time either. So you have your full rebuttal time, Ms. Nelson. Mr. Olson.
Great. Thank you, Your Honors. If it may please the court, as your honors know, we're here today to decide if a divorce can be arbitrated, and our conclusion to that is yes, it can. As this court's aware, you recently came out with a holding in the, I apologize for the pronunciation, Ahamingo case, I guess is my best at pronouncing that. And this court stated, when a party voluntarily agrees to arbitrate, she agrees to forego the protections of a substantive judicial review of the merits of the arbitration decision. A party should not be able to participate in arbitration and then subject the resulting arbitration award to the review it rebuffed in the first place. After all, arbitration is, at its core, supposed to be an alternative to litigation in a court of law, not a prelude to it. So I think that goes to one of the first questions your honors asked today. Was there some sort of waiver when they entered this arbitration agreement? My answer to that would be yes. There was a waiver because they voluntarily entered into the arbitration agreement knowing full well that the arbitrator was going to make that agreement. Yes,
But
Judge.
isn't that going to be true in every case in which a divorce matter gets arbitrated? I mean, the divorce case wouldn't go to the arbitrator unless the parties had agreed, first of all, that they would go to the arbitrator. So if that's true, we would never be able to review the propriety or the public policy around arbitration in divorce cases, isn't it?
Well, I think it's to an extent, but they don't have to go to arbitration. There's nothing that forces them to go to arbitration. It's a voluntary agreement. If they wanted to stay under the purview of the court to have all those safeguards in place, then they should decline to go to arbitration. I'm not aware of anything that would force somebody to go to arbitration in a divorce context, unlike maybe a contract agreement or something like that.
And isn't there another interest here just other than the two parties, or the two parties are the ones, David and Jill agreed to go to arbitration, but there are other interests at play in divorce cases, including the state's interest and the interest of children. Can a child's interest or the state's interest in these cases be waived by the two parties going to arbitration?
So I think the kid issue is an interesting question that you bring up. I don't think that arbitration in a divorce context is winner takes all in that regard. I think it could be spliced out due to public policy. For example, I think that custody would have a hard time being arbitrated, but that's not the fact that's before the court today. There was no custody arbitrated in this case. There was no child support that was arbitrated. So I think we're at a narrow question in arbitration in this sense, is if this case can be arbitrated. Yes, Your Honor.
Child support was part of the arbitration, right? In terms of fixing the two levels of the two parties' incomes, and in terms of what the inputs are going to be for the guideline child support. I mean, I thought both alimony and child support were part of what the arbitrator dealt with. Am I wrong about that?
No, you're correct. I guess I misspoke there to an extent. The actual custody itself wasn't arbitrated. They stipulated that outside the court. But yes, when it comes to, I guess, the income of the parties, that was arbitrated in this case. But I still think that's appropriate because that was just going off the facts that was before the court in that situation. Did I see a hand down? Yep.
Yeah, but Judge Harris, have you exhausted that line? Okay.
Justice Pierce, I have one question.
Okay.
In Judge Harris's, is that okay?
Sure, of course.
Okay. I think the child support issue is a tough argument for your side, because even though it wasn't really disputed here and it's within the guidelines, it's a good example of something that the parents don't have the power to bind the court to accept. They just don't have the power to do it. If for example, one of them, if here one of the parties said, I have zero income, the district court would routinely say, no, I'm going to impute at least minimum wage to you. I don't accept that. Or if the arbitrator ordered something that was not within the child support guidelines, a district court would reject that, and the parties have no power to stop the court from rejecting that. And I'm just not sure what to do with it, because it seems like it's a lack of power by the parties and the arbitrator to do what you normally would be able to do in the arbitration setting.
So that's a great question, and I've actually thought a lot about that aspect because I knew that most likely that would be coming up today. And I think my answer to that, Your Honor, would be if the arbitrator just didn't follow the guidelines or said, you know what, we're not going to award child support at all, I think that's a manifest disregard for the law. And I think in that instance, there would be able to either be setting aside the arbitration award or being able to modify it based on the arbitrator exceeding his authority. Because as you are well aware, and I think I'm well aware as being a family law practitioner, is those are the types of stipulations that are routinely rejected if the court has any qualms or hesitancy about the child support amount award. And if that were the case, and there wasn't an award of child support, then I think that's a manifest disregard of the arbitrator's authority and it could be set aside. Did I see a hand over here?
I just want to make sure that Justice Peterson has exhausted her. Yeah, so You referenced, and we call it amigo. I'm not sure if that's the correct pronunciation either, but amigo casts doubt on the existence of the manifest disregard ground for setting aside an arbitration award. So let's say that manifest disregard does not exist, and that an arbitrator only exceeds her authority when she applies a law other than the one the parties contracted for in their arbitration agreement. How does that change the answer you just gave to Justice Peterson?
So I think that's a good question. When I was reading that case in preparation for today, I think this court used the example of they have to have the benefit of their bargain, or it'd be like the judge applying Colorado law instead of Utah law. But I still think it would be the arbitrator would be exceeding his authority even in that sense if he just didn't apply Utah's law for purposes of child support. So if he didn't apply the law in Utah, not just misapplied it, but didn't apply it at all, then I still think it could be set aside based on exceeding his authority as an arbitrator.
Let's say we disagree with you, and we don't think that's what that language means. That's not how an arbitrator exceeds her authority. How does that change your answer to Justice Peterson's question?
I think I would have to get a little bit more context from you, Your Honor, to say what does this court decide is a disregard of that authority to mean? Because I think right now, going off the case law that we have, that would still fall under that umbrella.
Let's say that it means that you apply the wrong set of laws.
Just from a different state, just a
different state's law. You said the parties agreed that Utah law would apply. Court applies arbitrator applies Colorado law. That's manifest disregard. Parties say Utah law applies. The arbitrator makes a dog's breakfast out of it, totally messes it up, but nevertheless applies the right law. We say that's what the legislature, when the legislature passed the Uniform Arbitration Act, it did not consider that to be exceeding authority. So how does that change your answer?
So that makes it a little bit more problematic, because then we're setting a very high threshold to be able to correct an arbitrator's decision. And without it being in front of me right now, I would have to assume or have to argue that's not the legislature's intent either, for an arbitrator to.
Yeah, let's stipulate that you're going to lose that argument, and let's focus in on the one I'm asking, which is, if that is what it takes to set aside an arbitration agreement, can you arbitrate? And maybe, and this is one problem I have with the way the parties have briefed this case. I think sometimes we conflate arbitrability with grounds to vacate. So let's say that you could arbitrate issues involving child support, but what would the court's ability be to ensure that award is in the child's best interest, right? Or let's say they can arbitrate custody, but what level of review could the court apply to make sure that is in the child's best interest if manifest disregard isn't a thing?
I think I have to concede that argument, Your Honor, that I don't know if there would be a way, so that makes it very difficult. Without that manifest disregard there, I think it would tie the court's hands in that situation, which is why I think, to an extent, like I said earlier, custody things would be hard to arbitrate. But I think property settlements and things like that, or how to divide the assets, is much more arbitrable, or however you say that. Sorry about that. I saw another. Do you have any more questions for me, Your Honor?
Then what's your reaction to Ms. Nelson's? We were asking her some questions about this, and in response to some of those questions, she said, well, the court could create a situation where an arbitration award functions somewhat like a recommendation. What's your reaction to that suggestion?
I think there's a few things, and to couch that with a little bit of case law, I think we need to understand that, I think, with all due respects to Ms. Nelson, she's painting with a little bit broad of a brush where it's always just a recommendation. That's the prevailing case law, but we have a lot of other case law, for example, that says these parties are able to contract with how they see fit. We have other case law in the White House case where the court even acknowledges that they believe that the stipulation might not be equitable, but they're going to hold the parties to the benefit of their bargain and not come rescue them from something that they believed was inequitable when they had the right to contract for it. And even taking it one step further, we had the Premarital Agreement Act that has similar language to the Arbitration Act, where there's no judicial review in that case. if the party agrees to a prenuptial agreement, there's no fraud, there's no duress or anything like that, then the court's going to uphold the premarital agreement as well. So in coming back to your question, how do I feel about it just being a recommendation? I think a recommendation for a stipulation is different than than an arbitrated agreement, because there's different things that need to be considered. Namely, an arbitration agreement is somewhat of an adversarial process the majority of the time. There's other safeguards in place to ensure that the law is being followed. There's other safeguards to ensure that evidence is being presented. And there's other safeguards to make sure that you have a neutral third party making those decisions. Whereas with a stipulation, the parties can just come to an agreement on their own without any help of any professionals or anything like that, and submit it to the court and hope that the court will sign off on it. And I think that's one of the main reasons why a stipulation is just a recommendation, and why I would argue that an arbitration agreement should not just be a recommendation for issues that we deem to be that can be arbitrated, like alimony, property division, and things like that.
Judge Harris, I have a follow-up question to what you just asked. Are you finished? Mr. Olson, what if we were to say the arbitration award is binding on the parties? It's a binding stipulation on them, but not on the court. It's just a recommendation to the court. How would that, and it seems that there would be value in that, where you have multiple mediations and the parties couldn't come to an agreement. They could say, look, we can't come to an agreement, but we'll go to an arbitrator who comes up with an agreement for us and binds us to it, but it's a recommendation to the court. What are your thoughts about that? How does that fit in with the arbitration law? What's your position on an outcome like that?
So if I understand your question correctly, Your Honor, you're saying, what if the parties agree to be bound by the arbitration award so long as it's accepted by the judge? Is that what you're saying?
Yeah, so they're bound to it as a stipulation that will be presented to the court, because they couldn't agree on their own. The arbitrator is saying, here's your agreement. This is what you are bound by this, but the court is not bound by it. It could then go to the court, and the court has the same sort of power it normally has to revise things if it thinks that it needs to, even if it's less than a manifest disregard.
Yeah,
The court might just think it's not correct.
So if that's a carve out that we could do, I think it would be acceptable, because it would still bind the parties for the arbitration agreement, but there would still be some sort of judicial review there. And I think that's because, like Judge Harris was saying, because right now the arbitration agreement and the arguments are based more on the case law, I think that's something that Your Honors could probably carve out in a decision. Yes, Your Honor.
Would that be consistent with the language of the Arbitration Act?
Which provision? That it can't be amended?
Doesn't the Arbitration Act make it binding on the court, that the court must accept it?
Yes, and I think that's part of the argument that Ms. Nelson was making, that the court must accept it. But that's why I would somewhat go back to Section 107. And if you look at 107, the court could invalidate that arbitration agreement, or my argument would possibly even be able to modify that agreement if there was a reason to do so in equity. But that goes to the actual contract itself, and I'm not sure if that would extend to an award. But I think the court does retain somewhat of a jurisdiction to make corrections or to hold if something was inequitable under Section 107. For example, if the parties agreed to arbitrate and there comes out to be no child support, or it's just some crazy outcome of the arbitration, I believe that the court, because if you look at 107.2, it's the court who could deem if an arbitration was, the arbitration agreement was valid. But it also says that the court has the ability to set it aside or invalidate the arbitration agreement if there's something that exists at law or in equity. And so my argument would be that possibly, if equity would require it under the divorce setting, that they could set aside the whole arbitration agreement if they believed it failed to coincide with the prevailing statutes and divorce case law.
So could the court, well, I guess my question is, back to the one about, does the whole arbitration agreement go out the window if there's something that's revocable or void, or only the part of it that's a problem? Because it seems like and this might conflict with the arbitration statute. It seems like we could say the only thing that is void about this is the part that makes it binding on the court. So now that's kind of a big part of an arbitration award. but can parts be invalidated but other parts remain?
So almost like a severability argument that they can sever certain parts of it. I don't know. I would have to look through the arbitration act, but based on the statutes for divorce law, I've had many times, well, not many, but a few times when the court has said, we don't like this provision and we're going to take it out, and then they kept everything else in place. And so in that regard, I think that would be appropriate because it still allows the court to make those decisions and to quote unquote have the final say when it comes to the equitable distribution of the property of the parties. But again, I think we have a large line of case law that says these parties should be bound to their agreements and not come to regret the benefit of their bargain. And that's what we're seeing here. It was Mr. Taylor who wanted this arbitration. It was my client who agreed to it. I have a feeling that if he got a lower amount of alimony that he was expecting or something in that regard, we wouldn't be here today.
Justice Peterson, have you closed off that line? Can I, if I can take you back to your answer to Judge Hagan's question and also what you said just now. I mean, part of what you're talking about, that getting a second bite of the apple, I think is caused by the way that you and also Ms. Nelson are talking about Section 107. And it causes me to wonder whether I'm reading 107 incorrectly. But 107 seems to talk about the existence of an agreement, right? And it seems like maybe the time to raise that challenge is before participating in arbitration. The way that you were just talking about it in response to Judge Hagan's question, the way that Ms. Nelson was talking about it earlier, it seems like that is an additional ground to vacate an award when 124 gives us a closed list of the grounds for vacature. So I'm wondering if you can tell me, am I reading 107 incorrectly? What in 107 permits a party to go through arbitration and then assert the enforceability of an arbitration agreement when they've already participated in that arbitration?
I think that's a great question. And when I was preparing the briefing and when I was going through the Arbitration Act, I looked for any sort of timeline and when you had to challenge the arbitration agreement. I think logic would say is that you would have to challenge it before you even went to the arbitration. But the answer to your question, Your Honor, is I don't know, because I didn't find anything in the arbitration. I didn't find anything in the case law that specifically stated when you had to challenge that agreement. So I think that's why Ms. Nelson and I are arguing that can become almost as a hindsight argument to come and try to invalidate the agreement itself. Because you're right, it's not in the Section 124.
Yeah, so I mean, Section 124E allows you to vacate or to attempt to vacate on the grounds that there's no agreement to arbitrate.
Mm-hmm.
And then it says, unless you participate in the arbitration. And so, I mean, to the extent we're looking for things that are similar and might speak to this situation, it seems like no agreement to arbitrate is a lot like no enforceable agreement to arbitrate. And that perhaps you waive that by participating in the arbitration, and you have to find a ground under 124 or, avail yourself of that public policy ground that we talked about in Boozes v. Salt Lake Bees.
I would think that's a reasonable interpretation of what you said. I just didn't see anything in the statute itself that said there was some sort of time constraint on when that had to be challenged. If there's no other questions, I've got 16 seconds left, so I appreciate the time, Your Honors, and we ask that you affirm.
Thank you, Mr. Olson. Ms. Nelson, do I understand correctly that you'd be completely satisfied with the result if we were to conclude that in the context of divorce cases, an arbitrator's reward can be no more than a recommendation? Correct?
Yes, if the previous line of questioning made me a little nervous about it being binding on the parties. If we are also getting rid of manifest disregard. And we're saying that if you go to arbitration and the arbitrator just disregards Utah law, then there's nothing you can do about it. I think that we need that opportunity to be able to say to a judge, wait, they disregarded Utah law entirely, right? They didn't follow the Jones factors. They didn't follow the imputation statute. They didn't follow the custody statute or we need to let parties know that really there's no manifest disregard, and that if you go to arbitration and the arbitrator doesn't follow Utah law at all, then you're stuck with it. I mean, that's an important point. And if Justice Pierce is saying that that's where Amigo is going, and I understand that that's where it looks like Amigo is going. But if that's the case, then I think we've discussed, or with Mr. Olson, we've discussed that presents a real problem in the ability of the judge to set something aside if it doesn't follow Utah law, right? I mean, it may or may not follow Utah law. And I think we have a question then, what happens later if you try to modify a decree that has an error of Utah law baked into it? I mean, I think that creates additional problems when you get into modification. While I'm on Amigo, I want to talk about paragraph 46, which starts off, when a party voluntarily agrees to arbitrate, she agrees to forego the protections of a substantive judicial review of the merits of the arbitration decision. That's my problem. Divorce law doesn't allow that. And so that's where these two things don't come, they don't come together. They don't work in the divorce context. I also want, go ahead.
If we construe the reward in the divorce context as a recommendation only, that would allow a substantive judicial review, correct?
Yes.
In that event, what are your thoughts on with what standard would we assess or review a recommendation?
I think with the same standard that applies to mediations, and mediations is a better comparison. I was going to say custody evaluators, financial advisors, whatever. But mediation is a better comparison because we do have case law saying, on the one hand, parties are bound by their contracts, and on the other hand, but married parties and soon to be married parties aren't necessarily dealing at arm's length. And so we need to make sure that somebody is supervising it to make sure that equity is being done. And that's where that would be the same standard that would have to apply here to make sure you've got equity, you've got Utah laws being followed. The child support guidelines are a perfect example, but the Jones factors are an example also. What if an arbitrator decided not to include the recipient's ability to support herself at all? Not just to disregard the imputation statute, but I'm not going to worry about that. I mean, the judge would need to be able to say we can't do that.
If we were so inclined, analytically, how would we get to that conclusion that in the divorce context we construe any arbitration award as a recommendation only?
Well, I think it's a problem because the Arbitration Act tells us that it's binding, right? That's what you were discussing with Mr. Olson. But I mean, this court could do it. I think that a statutory amendment is cleaner, but this court could say that our case law in the divorce context requires this, and to the extent that divorce law and the Arbitration Act can interact, then we're going to apply to arbitration awards the same rules that we apply to mediation agreements. I think that's how we would get there. We would say that an arbitration award is like a mediation agreement. And in fact, it is, right? Because I think the context that has been discussed makes sense, where parties are able to mediate some things, maybe custody. All right, we're going to have 50-50 custody, but we can't quite figure out the financial piece. So it'll be faster and cheaper if we go to an arbitrator. That's fine, as long as in the end, the judge can make sure that that's okay. And I do just want to say that I think that the fact that parties in a divorce may have different levels of power is a thing we need to keep in mind, because under 124, a court can only vacate an arbitration award if a party moves for it. But if you're divorcing and one person is being really manipulative to the other, they've got all kinds of leverage, they've got the kids in play, you know, and they say, you better not challenge that.
Is there
If
any
you
evidence?
challenge it, I'm going to keep the kids this weekend, you know, whatever. We've got a real problem there.
Is there any evidence in the record that this arbitration agreement was the product of emotional manipulation?
No, but that wouldn't necessarily show up in a record, right? That's the point of an emotional manipulation, that one person would manipulate someone into saying, you better not do that. Now, I understand that there could be a time when a person might have the nerve, the guts to say, I'm going to challenge it anyway. I'm going to challenge it under 124 as undue means. But I'm concerned about the ramifications that could happen if she did that. And I think that's exactly why Utah law makes sure that the judge and not the parties have the final say in what happens in a divorce. Justice Peterson.
I have a different question. Justice Pierce, are you done with that line? Ms. Nelson, I have one question about 107 again. So to me, the language looks to be talking about it's the title of 107, the validity of the agreement to arbitrate. So a challenge on the front end that arbitration is going to be imposed on the parties. And it could be read to be saying that if you're challenging an arbitration agreement and you don't want to go to arbitration, then that agreement to arbitrate, which is in a contract or a record, as it says, can be revoked for any reason at law or equity that exists for revoking a contract. But the contract they're talking about revoking is the agreement to arbitrate, not the arbitration award itself after it's happened.
Oh, I agree with that. But if you set aside the agreement to arbitrate, then it follows that you set aside the arbitration award as well.
Right. So doesn't that make it hard to pick out parts of it? And when I'm talking about a part, I mean the part about it being binding on the court to say, look, this is all okay, but the parties don't have the power to make this binding on the court. So we will construe this as binding for all purposes up until the point where they don't have the power to do it. And that is to bind the court. So that's voidable, or that's void. Maybe they don't have the power to do that. That's void. But the rest of it's okay. If this is about the whole agreement to arbitrate, does that limit the ability to do that, to pick and choose parts of it?
I mean, I think so. I don't think that this court actually can just say, we've decided that this statutory provision doesn't apply, that it's binding. But I mean, with all due respect to the Supreme Court, right? You can, but that's why I think a statutory amendment is better. But my position is that, all right, you've got an arbitration agreement, and let's keep in mind that most arbitration agreements are not entered into like this. Most arbitration agreements are entered into when you sign up for your cell phone plan and you get a 20-page document, and in there's an arbitration clause, right? And then a couple years later, you are in a dispute with AT&T, and all of a sudden, boom, you have to go to arbitration. That might be a good time to say, and I don't think this arbitration agreement is valid. But in a context like this, where there isn't a pre-existing contract, and you enter into a contract at that moment, why would you enter into a contract at that moment if simultaneously at that moment you think it's not arbitrable, right? And I think that's where Justice Pierce's question about the timeline matters. I mean, Mr. Olson's right that there's no timeline in the statute about when 107 applies. I see 107 as being a bigger picture than 124, not a missing subsection of 124. There's 124, you can vacate the award, but you might not necessarily vacate the arbitration process under 124, right? You can vacate it and send it back for a rehearing. That's one of the options. But I'm talking here about just I'm sorry, the arbitration agreement wasn't valid. You couldn't enter into it. Therefore, the arbitration award is out. Justice Pierce.
How do you square that with 124E?
That exceeded the authority.
124E, there was no one of the grounds
No agreement.
There's no agreement to arbitrate unless the party participates in the arbitration proceeding without raising an objection.
Well, I read that sort of being like Rule 15, where you don't have a claim, but if you bring it up at trial, then you've effectively decided that there was a claim and that's okay. So I read E as saying, well, there wasn't an agreement to arbitrate, but we did it anyway. So that's okay. Would there be a ground that exists at law or in equity to not have done it? Well, then maybe 107 would apply. I mean, obviously that's not this case. I understand you're just, examining what happens here, but I mean, that's my answer. 107 says, okay, we've got a contract, you can set it aside. 124(1)(e) says, okay, you don't have an arbitration agreement, but you did it anyway. Now what do we do? Well, you might vacate it, but it might not be because the whole concept is not arbitrable. It might just be that in that particular case, something went wrong. If there are no further questions, I think we've been over this. We would ask this court to reverse. I don't think that there's a way to break off one piece. We haven't talked much about imputation. If there is a way to break off one piece, then let's do that. But I think that under 124, you just vacate the whole thing. There's no other option if vacatur under 124 is the appropriate method. We would ask this court to reverse the district court's award, set aside the arbitration, and send the case to trial.
Thank you, Ms. Nelson, Mr. Olson. We appreciate your arguments, and we will take this matter under advisement. We'll be in recess until 10:15, at which time we will return and hear the case of Bonner County versus Western Insurance. Court is in recess.
Perfect. Thank you, Your Honors.